Hello, everyone. My name is Mark Tarbox. I am the Director of TEP Education at the Eviction Defense Network, and I am here to assist you with Form Interrogatories Unlawful Detainer, which is one of the forms of discovery requests you can receive from the opposing counsel. If you receive discovery requests from the opposing counsel, including form interrogatories, special interrogatories, requests for admissions, requests for production of documents, you should immediately request an extension of 2 weeks because otherwise you only get 5 calendar days to respond. So you email the opposing counsel requesting 2 weeks extension. Sometimes they respond, sometimes they don't. If they respond, they'll either grant your 2-week extension, deny the extension, or give you a shorter amount of time to respond than the 2 weeks you're requesting. And you should communicate by sending your PIP to your attorney law clerk at 10 a.m. Monday through Friday when you receive discovery, letting them know you've received the the requests, and when they are due. If you requested an extension, you're going to let them know you requested an extension and when that extension deadline will be. When you request the extension, you can ask that objections be preserved, meaning you're allowed to object to certain questions that you either don't understand or you think are irrelevant. And you want to preserve the objections if you can. You can request that objections be preserved as part of your request for an extension. Otherwise, you can only object during the first 5 calendar days after you receive the request. So if you ask for an extension, say, I would like to request 2 weeks extension to respond to your discovery, preserving the objections. The opposing counsel may respond, letting you know that you can have the extension as long as you don't object. And you will most likely agree to that because it's more important to have the extension than the objection. Okay. So the first thing to remember, you're going to send a request for an extension, 2 weeks, with preserving objections, and you're also going to inform your attorney law clerk team 10 a.m. Monday through Friday, letting them know you received discovery requests, especially if you have requests for admissions, because the attorney law clerk team is most likely going to assist you with those responses. And you want to respond to them quickly because they can do the most damage to your case if you don't respond timely. You want to make sure you get those done. So you're going to communicate to your attorney law clerk team, letting them know that you received requests for admissions and is anyone available to assist. They will usually assist you with the admissions and then direct you to this class to complete the rest. And we're going to go over the form interrogatories unlawful detainer today. I have on the screen what the form interrogatories unlawful detainer look like when you receive them. Everyone receives the same form interrogatories unlawful detainer document. This is the standard document used for form interrogatories unlawful detainer. These questions are not written by your landlord. They are not written by your landlord's attorney. They are written by the court. They are commonly used in unlawful detainer cases. The only thing the opposing counsel does with this form is check the boxes of the interrogatories that you are to respond to. They don't typically check them all. They usually just check the ones they want you to respond to. We are going to go over them all, however, one by one, but please note that while we're doing this, you can answer you can use the response template to answer while we're in this class, and you only have to answer the questions, the interrogatories that are checked by the opposing counsel on the form interrogatories unlawful detainer you received. Hopefully you have that in front of you. And so if you don't, you take this time to get those interrogatories in front of you so that you know which ones you have to respond to. Some of the form interrogatories are designed for both parties to respond to, both the landlord and the tenant. Some questions are more designed for the tenant to respond to, other questions just for the landlord. And sometimes the opposing counsel checks boxes of interrogatories that typically the landlord would respond to. And that can be done to trick you into putting a response in that that you wouldn't ordinarily give. We'll go over those when we get to them. Always remember, as we're going through this, that I am not an attorney. I am not here to tell you what you should do. What you should do is what you believe is the correct response for your case, for you and your situation. We go through the questions in an attempt to help you understand specifically what the question is asking. And then we'll discuss some suggested responses from the EDN attorneys. However, they are just suggestions. You should always put in the response that is appropriate and true for you. And sometimes that response might be that you don't know the answer. Whatever is true for you is what you should put in. We're not going to tell you here that you must put in a certain response. You're going to always put in the response that is appropriate and true and complete and accurate for you. Okay, we're going to get started. I'm going to pull up the template that we use for form interrogatories unlawful detainer. I posted 2 versions in the chat. These documents can also be found on our shared drive. I'm going to post the link to the shared drive in the chat. Okay, now I'm going to pull up, you should now see on your screen the response template. And this template is for responding before the deadline. So either within the first 5 days of receiving the discovery, and when you receive the discovery, the day you receive it is day 0. And then there's 5 days to respond. If the discovery is given to you in person, that's day 0, 5 days to respond. If the discovery is sent to you priority or overnight, you get 7 days from the postmark, which turns out to be typically 5 days because of the 2 days that it typically takes for the mail to arrive. So 7 days from the postmark is day 0, and then you count 7 days. If the requests are sent to you first class mail, you get 10 days from the postmark. Often works out to be about 5 days, calendar days to respond. In either instance, you're going to request an extension of 2 weeks from the opposing counsel, and hopefully that request is granted. Okay. The first thing we're going to discuss is the caption page, which is this page here. And sometimes there's more than one named occupant in the unlawful detainer case. And if there's more than one, however many there are, whoever answers the complaint is also typically going to receive discovery requests. So even though there may be 2 or 3 or more of you, you will all receive discovery requests, and you will all have to answer them separately, even though in many instances, your responses are going to be the same. And so you're going to each submit responses. Each person, individual person, puts their name and address at the top. Only the one person responding puts their information at the top. This is where the name of the plaintiff goes, and you want to make sure you put it in exactly the way it's listed in the complaint. This is where you put the named occupants in the complaint. So even though only one person is responding, you're going to put all the named defendants, all the named tenants, occupants here. And you're going to put the names exactly like they are in the complaint, even if they're mistakes, even if they got your name wrong or they spelled it wrong, you're going to put it in exactly the way it's written in the complaint. And then you're going to put the case number here. The propounding party is the plaintiff, and so whatever you put here, you're going to put here. The responding party is the one specific person that is responding in this document. Remember, there's more than one person here. Each person has to be responding on their own document. So this here is where you put the name of the person who's actually responding in this document. It should be the same as the person up here. Name, address, and phone number. The responding party is the one person of the people named here that is actually responding in the document. Next is the objections. And these are just general objections that we're not going to go into now. But note that if you are within the 5-day calendar day deadline to respond, then you can check here, general objections to all requests. You can use the other version of the discovery that I posted in the chat for after the deadline. It has the objections already removed. It makes it much simpler. If you know you're going to be late, meaning you're going to be after the deadline, whether it be the first 5-day deadline or even after the extension deadline, if you know you're going to be late, you can use that other version that says after deadline. It has the objections already removed for you. If you're not sure you're going to be on time, but you might be on time, you can wait until you send them to check this box. If you're on time, you check here. If you're late, you check here. The first question is about who is assisting you with your responses. And assisting you with responses is about looking at your specific case and helping you, based on your case, how to answer the question. We are not doing that today. What we are doing today is we are helping you understand what the questions are asking you. And there are some suggested responses on the template that you can consider, but the decision about which response to use is yours to make. Not anyone, not myself or anyone at EDN is going to tell you what you must, how you must respond. We're here to help you understand the questions, and then you put in your true response. And so the way the answer is written to this first interrogatory, which is state the name, address, and telephone number in relationship to you of each person who prepared or assisted in the preparation of these interrogatories. And the answer we have put in is that the responding party, which is the one person responding in this document, was not given direct assistance, but made use of the template provided by us, the Eviction Defense Network, and our address and phone number. And so if nobody at the Eviction Defense Network looked at your case details and told you how you should respond, then you should just leave this response here, because all you're going to be doing is using our template. Next, question 70.2. And remember, as we go along, that the opposing counsel checks boxes for you to respond. Many instances, there will be boxes that are not checked, and you don't have to respond to those. You shouldn't respond to any box that's not checked. If it's checked, you should do your best to respond. If 70.2 is checked and your form interrogatories, the question is asking, is the plaintiff an owner of the rental unit? If so, state the nature and percentage of ownership interest and the date plaintiff first acquired this ownership interest. This is typically a question that is asked of the landlord, because this is information the landlord would know. It's not information that the tenant typically would know, although that may be different in your circumstance. If, for example, you saw the deed that has the plaintiff's name on it and are able to answer these other parts of the question. If you didn't see the deed and you're not sure the plaintiff is the owner, even if the plaintiff told you they're their owner, they are the owner, even if the plaintiff's name is on your lease or rental agreement, it doesn't necessarily mean they are the owner. They'd have to be on the deed. And many times there's people listed on leases and rental agreements that are not the owners of the property. With questions in these interrogatories, you want to be 100% sure in order for you to say you know something. If you don't know, that's an honest answer. And in this case, if you don't know, the first response is responding party lacks personal knowledge. Otherwise, you check here and you put in your response. If you have questions as we go through this document, please write them privately to me in the chat. And at the end, we can go over any questions that came up during our review of the individual interrogatories. Please be sure to reference the interrogatory number if you have a question about a specific interrogatory. Next question, 70.3. Does plaintiff share ownership or lack ownership? If so, state the name, address, and nature and percentage of ownership interest of each owner. Again, this is a question typically asked of the landlord. And so it's not supposed to, or typically checked, for tenants to answer. Sometimes it's checked. If it is, then you put your honest response. Do you know the answer to this question? Don't go based on what someone may have told you. You go based on what you actually can confirm from tangible evidence. If you don't have any tangible evidence, consider this response, that you lack personal knowledge. Otherwise, if you do have factual evidence, you'll check here and you'd put in this response. Question 70.4. Does plaintiff claim the right to possession other than as an owner of the rental unit? If so, state the basis of the claim. Once again, this is a question typically asked of the landlord. It's asking what the plaintiff claims, right? You'd have to get inside the head of the plaintiff to know the answer to this question, what the plaintiff claims. So if you don't know, you put this response, lacks personal knowledge. If for some reason you have a different response, you would check here. Typically, this box wouldn't be checked for tenants to respond, but sometimes opposing counsels check as many boxes as they can. 70.5. Has plaintiff's interest in the rental unit changed since the acquisition? If so, state the nature and dates of change. Again, this question is typically asked of the landlord. It's asking about plaintiff's interest. You'd have to get inside the plaintiff's head to know what plaintiff's interests are. And so most likely you're going to use the first response. However, if that's not accurate and you have a different response, you check here and you put in your response. Question 70.6. And this question is typically asked of both parties. Are there other rental units on the property? And if so, state how many. And the question is asking about other rental units, so not including yours. So if you're living in an apartment building and there are 100 units total, and one of them is yours, there are 99 additional rental units on the property. If you know this information, you check here and you can put in the number of additional units here. Otherwise, you can check here. This would be if there are no other additional rental units. Sometimes people are living in a single-family home, for example. If you're renting a single-family home and there's no additional rental units on the property, then this would be the appropriate response. 70.7. During the 12 months before this proceeding was filed, did plaintiff possess a permit or certificate of occupancy for the rental unit? Now, this seems to be a question for the landlord to answer, but the landlord is required to post the permit and the certificate of occupancy in the common areas of the property. And so this is a question that both the landlord and the tenant could conceivably answer. And if you don't know, you would check this one. If you know for a fact that there is no permit, no certificate of occupancy, you would check here. And any other response, you check here and put in the answer. Form interrogatory 70.8 is asking about any additional amount of money that you may have paid either the landlord or the property manager when you signed your rental agreement. This covers things like the last month's rent, a security deposit, a cleaning fee, rental agency fee, credit check fee, key deposit, or any other deposit paid on the rental unit. And so this question is asking, in addition to paying your first month's rent, did you also pay the landlord the last month's rent? And last month's rent is typically the very last month in the agreement. So hypothetically, if you sign a lease for a year, when you move in, you pay your first month's rent. And in some instances, the landlord may have requested a last month's rent, meaning the very last month you're going to be living in there, they want that prepaid. And they could also request a security deposit. It's unusual for there to be last month's rent in newer agreements. I'm not even sure they're still allowed, but if you had an older agreement from years ago, last month's rent was pretty common. The landlord would be asking the tenant to pay the first month, the last month in advance, and potentially a security deposit equal to 1 month's rent to cover any potential damage done to the unit. There are also these other types of fees that could have been paid to the landlord or property manager. And if so, you're going to put, if you have one or more of these that you paid, you check here and you fill in the chart. The purpose of the payment would be whether it's last month's rent, security deposit, a key deposit. Sometimes they have, pet deposit, whatever it is, you put it up here in this line. The date you paid it, the amount you paid, the form of payment. Was it check? Was it money order? Payer is did you pay or did one of your roommates pay? The payee is who received the payment. And then this is for any evidence you have of those payments. If you have evidence of those payments, you would put those in your trial binder, your exhibit portion of your trial binder. And this answer is basically saying, if you check here, you're saying, yes, I have documents. If I have those documents, I'm going to put them in my binder. And the demand for inspection of documents is the request for production of documents. It is almost always included with discovery requests. It's the landlord, the plaintiff, asking to see your tangible evidence, which they are entitled to see. And you are required to give them whatever evidence they ask you to provide as long as you have it. If this doesn't apply to you, you didn't pay a last month's rent, security deposit, cleaning fee, any of these additional fees, you check no. And you go to the next question. If you did pay one or more of these, you check here and you fill in the chart. If you don't have the document evidencing the payment of any of the security deposit, etc. above, then you check here and write in your response. Question 70.9 is asking you to state the date the defendant first took possession of the rental unit. This is a question that both parties could answer. And so you're going to put the specific date that you moved into the premises. Of course, if you don't remember exactly the date, you can write on or about a date. Or if you don't even know what date it was, but maybe you know the month, you put on or about that month and year. You want to make it as specific as possible based on your recollection. If you have tangible evidence, you should try to find that to give the most accurate answer. 70.1 is asking you to state the date and all terms of any rental agreement between the defendant and the person who rented to the defendant. This is a question that can be answered by both parties. And basically, it's asking for the terms in your rental agreement or lease. And you don't have to write out all the terms in your rental agreement if you are given and you have a tangible rental agreement or lease. If you have it written out, then you just need to include it in your trial binder as Exhibit 101. Exhibit 101 is always the lease or rental agreement, and that's where you should put it in your trial binder, in the exhibit binder section. If you have your lease, you check here and you make sure that your lease is included in the binder. And so that when it's scanned and included with the request for production of documents, this is where you're telling them to look for it. You check here if you have an oral or verbal agreement with the landlord for your rental of the unit. You check here, and then you put the monthly rent that you agreed to pay here. If neither of these apply, you check here and you put in your response. Question 70.11 is asking for each alleged agreement in the pleadings, identify all documents that are part of the agreement, state each part of the agreement not in writing, identify all documents that evidence each part of the agreement not in writing, and identify all documents that are part of each modification to the agreement. This is asking you about changes to the original agreement. Sometimes during the course of a tenancy, the landlord or property manager changes the rules from what was written in the original lease. You'll get some form of a formal notice, usually in writing, letting you know of some policy that's either changing or being added or removed from the original agreement. The most common example of this is when your rent is increased. You get a notice from the landlord or property manager letting you know that the rent is going to be going up starting on effective this date. And that is a piece of evidence that you would want to have included in your exhibits as part of your trial binder. And so this question is saying it wants all evidence of all agreements, either in writing as part of the original agreement or evidenced in some other way. This can come in different forms. Sometimes landlords communicate via text, sometimes via email, sometimes by notice or letter, right? You're going to put whatever applies to you. How did the landlord or property manager inform you if there was anything to be changed? Sometimes people rent a unit, there's no rent increases, there's no changes to the agreement, and so this wouldn't apply to them. If it does apply to you, and it does apply to most people, if you have the written lease, you have evidence of other information that would explain changes in the agreement, you're going to put it in your exhibit binder. The lease is Exhibit 101. Exhibit 102 is your rent payments. So if the landlord increased your rent, and maybe you don't have a copy of the notice that was given to you that says effective this date, your rent is going up, the fact that you have evidence of your rent payments will also prove that change of the agreement, that the rent went up, because that's reflected in the change in your payments. 103, Exhibit 103, is communication between the parties, tangible communication, meaning emails, text messages, letters, notices. So if you do have a copy of the notice that gives you notification of some change or addition or removal of a policy of the lease, you would include it in your trial binder under Exhibit 103. And so if this response applies to you, you check here. If you had a verbal agreement and all the changes were verbal, you check here, but noting that if there were rent increases, for example, or maybe some notices that were given even though your original lease was verbal, maybe you have some evidence of rent payments or communication about changes to the agreement from the landlord or property manager, you're going to include those as part of Exhibit 103. This response is for people who have a verbal or oral agreement to rent their unit. If neither of these responses apply to you, you check here and put in your response. 70.12 is asking, has any person acting on the plaintiff's behalf been responsible for any aspect of managing or maintaining the rental unit or the property? If so, for each person, state the name, address, and telephone number, the dates the person managed or maintained the rental unit or property, the person's responsibilities. This question can be answered by both parties. However, the plaintiff might have more specific information because it was their staff. You're going to be going based on whatever information you have. Was there someone other than the plaintiff that was helping the plaintiff manage the property? Either the property manager, could be someone who does repairs on a regular basis, someone who does the gardening or pool maintenance. If you know the names of those people, you include them here. If you happen to know their home address and telephone number, you include those as well. You're going to only put in what information you know. If you don't know it, you don't know it. Some of this information is more likely to be in the possession of the plaintiff. If there was no such person helping the plaintiff with the property, you check here. If there was someone, you're going to check here and then answer this to the best of your ability. The name, address, and phone number, the dates the person managed. Sometimes people have been living on their property a long time and there's staff that gets hired and let go and new staff. You're going to put the dates that they managed based on your recollection and their specific responsibilities. Did they collect the rent? Did they do repairs? Did they do the gardening? Whatever their responsibilities were. Form Interrogatory 70.13 is asking for each person who occupies any part of the rental unit, except occupants named in the complaint and occupants' children under the age of 17. State the name, address, telephone number, birthday, the inclusive dates of occupancy, a description of the portion of the rental unit occupied, the amount paid, the term for which it was paid, and the person to whom it was paid, the nature of the use of the rental unit, the name, address, and telephone number of the person who authorized occupancy, and how occupancy was authorized. Okay, this question is asking about roommates. It wants to know, are there people that are not named occupants in the complaint that live in the unit that that potentially were authorized by the landlord or property manager or not? So anyone that's an adult living in the unit that is that you're going to put, if there's no one, you check here. If the only people living in the unit are the named occupants and their children, if any, then you check here. If someone else is living in the unit other than the named occupants and any children under the age of 17, you check here and you fill in this chart. And specifically, the chart is asking for the name, address, date of birth of those people that would be living in the unit that are not named, the dates of occupancy, when did they move in, did they move out, the portion of the unit, did they only occupy a bedroom, the amount they paid per month while they were living there, the nature of use, was it residential or something business related, the name, address, and telephone number of the person who authorized. So when answering this question, sometimes the landlord or property manager doesn't put in writing that they agreed to let someone move in, but that the proof of their acceptance of that person can come in a different way. For example, if that person paid the rent directly to the landlord and the landlord accepted it. If the landlord accepted the rent over periods of time, that's equal to the landlord accepting or authorizing that person living in the unit. And you can put that as a reason. However, you want to have any evidence you have of the landlord granting that this additional occupant move into your unit. So if you have a roommate, you would typically let the landlord know so-and-so is moving in. Sometimes the landlords require a credit check, for example, on that person to make sure that they can pay the rent. If you have evidence of that authorization, you're going to answer here. Either the response from the landlord was verbal, it was in writing, or the landlord knew that this person or people were occupying the unit and failed to protest. If none of these responses apply, check here and put in your response. .14. Have you or anyone acting on your behalf obtained any document concerning the tenancy between any occupant of the rental unit and any person with an ownership interest or managerial responsibility for the rental unit? If so, for each document, state the name, address, and telephone number of each individual from whom the document was obtained, the name, address, and telephone number of each individual who obtained the document, the date the document was obtained, and the name, address, and telephone number of each person who has the document. Once again, this is about the rental agreement and any changes made to that agreement that are tangible. If you have the rental agreement and evidence of any changes to that agreement, like I said before, Exhibit 101 is the lease rental agreement. 102 is the history of rent payments. 103 is evidence of communication between the parties, meaning text messages, emails, letters, notices. So if you have evidence of any agreement with the landlord or property manager, you check here and you put those in your exhibit portion of your trial binder under those categories. If the agreement was verbal, you check here. If it was some form of hybrid response or some other response, you check here and you write in the response. 71.1. Was the notice to quit on which the plaintiff bases this proceeding attached to the complaint? If not, state the contents of this notice. So this question is asking you to look at your complaint for the notice to quit. This is the operative notice that is the basis for the eviction. It's usually something like 3 days to pay rent or quit, 30 days to pay rent or quit, or so many days to cure or quit, or perform or quit, or just so many days to quit. That is the notice, and it's usually attached as Exhibit 2 to your complaint. If it's not, right? If it is, you check here, yes. If no, you can check here, but you can also produce the operative notice that you have, meaning the notice that was posted often on your door or some other conspicuous place on the property. Sometimes it's delivered personally to you. Sometimes they knock on the door, but they're not required with the notice. They can just post it in a conspicuous place. If you receive that notice, sometimes it's mailed to you, but it's not attached to the complaint. You check here and you can produce that notice you received. Any other response, check here and you write out the response here. Form Interrogatory 71.2 is asking, state all the reasons the notice to quit was served, and for each reason, state all the facts supporting plaintiff's decision to terminate defendant's tenancy. State the names, addresses, and telephone numbers of all persons who have knowledge of the facts. Identify all documents that support the facts and state the names, address, and telephone numbers of each person who has each document. Now, this is a tricky question because it's typically a question that's asked of the landlord, but you might also be able to respond based on information you have received. So consider the different responses, because sometimes there's ulterior motives of the landlord that they make you aware of. Landlords often make mistakes, and out of anger or some other reason, they reveal their motivation for trying to get you out. And sometimes that motivation can be things like, you've been living here too long, you're not paying enough rent. If I get you out, I can raise the rent much higher, right? Sometimes landlords spell it right out. Sometimes they say it out loud. Other times they put it in writing. They'll text it or email it. And if you have evidence of that, you can include that here as the motivation behind the reason. What are the reasons that support plaintiff's decision to terminate your tenancy? It could be that you don't know the plaintiff's motivation, and you would consider checking here. If one of the other explanations below apply to you, check here. And if none of these responses apply to you, check here and write in your response. $71.3 is pretty straightforward, but time consuming. It's asking you to list all rent payments and rent credits made or claimed by or on behalf of defendant beginning 12 months before the notice to quit was served. That means you look not today's date, go by the date of the notice and go 12 months back and cover all those months and put them in one at a time into the chart, all the rent payments you made. Sometimes people make partial payments. You could have maybe paid a portion of the rent the beginning of the month and then paid the rest of the rent either in one other payment or two other payments. However it's done, if you make partial payments, each partial payment gets its own line, because you're going to put in the amount, the date it was paid, the form it was paid is whether it's check or cash or money order. The purpose is typically rent. Period covered is the month that you're applying the rent towards. This is the date you paid it. This is the month you're paying for. And then who made the payment. And then at the bottom, it's asking for evidence of those payments. Again, Exhibit 102 is proof of rent payments. You should have evidence of your rent payments. Hopefully you're all paying rent like a pro, and you're using cashier's checks or money orders to make your payments. Maybe you paid through a portal, and you have documentation of your payments that you can include as part of your exhibit binder. If you don't have evidence of your rent payments, you check here. If you do, you check here and you put that evidence in your binder. If neither of these apply, you have some other explanation, check here and write out your response. Interrogatory 71.4 is asking, did the defendant ever fail to pay the rent on time? If so, for each late payment, state the date, the amount of any late charges, the identity of all documents recording the payment, and for each, state the name, address, and telephone number of each person who has the document. If you always paid your rent on time, you can check no. If you had instances where you failed to pay on time, check the next box and fill out the chart. You want to fill it out to the best of your ability, going back to the beginning of your tenancy. But specifically, you want to make sure you cover, if you can, the 12 months before the notice, or longer if the amount demanded in the notice goes beyond 12 months. You're going to try to cover the period, especially going back to where the notice demands. But this question is asking, ever fail? So if you have information going back to the beginning of your tenancy, you should put that in here as well. You can put for date on or about if you're not sure, and you should always try to answer honestly. This part is asking, did the landlord assess a late charge? And this can be helpful information because there have been periods during the pandemic, for example, that the landlord wasn't allowed to charge a late charge. And so there could be an illegal late charge added. Also, the landlord in the demand to pay rent or quit is only allowed to demand rent, not any late charge or any other fee. And so if the landlord demanded rent, including a late charge, then that could be evidence that you would want to include that could potentially help you in your case. The bottom is about whether, if you don't have any evidence of the late payments, you check here. If you do have evidence of the late payments and any late charges, you check here and you include those in your trial binder under the exhibit section. And if neither of these responses apply, you check here and you write in your response. Interrogatory 71.5. Since the beginning of defendant's tenancy, has plaintiff ever raised the rent? If so, for each rent increase, state the date the increase became effective, the amount, the reasons for the rent increase, how and when defendant was notified of the increase, and the identity of all documents evidencing the increase. This is a question that both parties can respond to. If there was no rent increase while you lived there, just check here and move on to the next question. Otherwise, check here and you fill out the chart of the date, the amount, and the method of communication for each rent increase. If you have the notices or emails or texts in which the landlord used to notify you about a rent increase, you want to include those as exhibits in your trial binder. You want to especially include them if you suspect the landlord illegally raised the rent. There's limits on how much the landlord can raise the rent in most instances, and so you want to make sure you include evidence if you have it, so that the attorneys can look at the rent increase and determine whether it was a legal rent increase. And down below, you're going to check all the boxes that apply. Here, if the plaintiff's reason for increasing the rent is not within your knowledge, if you don't know what the motivation was, check here. If you believe you do know the motivation and maybe it was one of these responses, you check either here or here. Otherwise, if you know a different reason for the rent increase, you can check here and put in your response. And the next part is asking if you have any evidence, tangible evidence, documenting the rent increase. If you don't, you check here. If you do, you check here, and you make sure that you put that evidence in your trial binder in the exhibit section. If neither of these responses apply, you check here and write in your response. Interrogatory 71.6 is asking, during the 12 months before the notice to quit was served, was there a period during which there was no permit or certificate of occupancy for the rental unit? If so, for each period, state the inclusive dates and reasons. This is typically a question asked of the landlord, but it's often checked for tenants also, because they want to know if you know that there were no certificate of occupancy or permits posted. If you live in an apartment building, they are typically posted in the common areas. If they're not, you should document that. You should take a photograph of the common areas to evidence that there is no permit or certificate of occupancy posted. And if you don't know, but you think the landlord knows the answer, you check here. If you do know that the information, this question is, the question is specifically asking if there was no permit. So if you know, yes, there was no permit, you check here. If there's some other response that's appropriate, you check here and fill out the response. Interrogatory 71.7 is asking, has any person ever reported any nuisance or disturbance at or destruction of the rental unit or property caused by defendant or other occupant of the rental unit or their guest? If so, for each report, state a description of the disturbance or destruction, the date of the report, the name of the person who reported, the name of the person to whom the report was made, what action was taken as a result of the report, the identity of all documents evidencing the report, and for each state the name, address, and telephone number of each person who has each document. This is specifically asking about written reports for some form of a nuisance or damage. If the landlord or property manager ever was either by their own witnessing or maybe the witnessing of someone else who lives in the building or some other person came to the landlord or property manager to report you or one of the other occupants or one of your guests as committing either a nuisance or destruction, and you have evidence of that, you have to include that here. If that never happened, you just check this one and go on to the next question. Otherwise, you check here and you put in what reports you were ever given from the landlord or the property manager about some form of nuisance or destruction that you or another occupant of the unit or one of your guests committed. And then evidence. If you have no evidence here, if there is evidence, you put it in the trial binder. And if neither of these responses apply in terms of evidence, you check here. Remember, if nothing was ever reported, you check here and just go on to the next question. Okay, 71.8. Does the complaint allege a violation of a term of the rental agreement or lease other than non-payment of rent? If so, for each covenant, you would list those here. If there's no allegation of a violation of the lease, you check here. And an allegation of a violation of the lease might be damage to the property, loud noise, lots of different examples of a violation. You'd look at your lease and rental agreement and it tells you things you can't do, right? If the landlord found that you did violate the lease, they can send you a written notice letting you know you committed some violation of the lease. And if they're trying to evict you for that reason, that you would normally receive a notice that says you notice to either cure or perform covenants or quit, meaning you've got to remedy this problem, provide proof that you've remedied the problem, or move out. So if you received a notice about that alleges that you committed some violation of the lease, you're going to put in each individual allegation here, facts supporting or against the breach. If the landlord's accusing you of something but you didn't do it, or the person they're suggesting didn't do it, you'd put in that information here. And then the name, address, and name, address, and phone numbers of all people who have knowledge, meaning anyone who's witness to whatever this allegation is. If there are no violations, you simply check here and go to the next question. If there is alleged violations, you fill out here. You check this box and fill out the allegations. And then the bottom is about whether you have evidence to produce regarding the violations. Either check here or check here, depending on which applies to you. Remember, if there are no allegations, you check here and just go to the next question. Form interrogatory 71.9. Does the complaint allege that the defendant has been using the rental unit for an illegal purpose? If so, for each purpose, you're going to state any illegal purpose. If nothing is alleged, no. This is rarely checked. It's very uncommon. But there are obviously examples that it could happen. If the landlord is accusing you of doing something illegal on the property, they will give you a notice with the alleged illegal purpose. You would check here and then list those here, facts supporting or against whatever is being alleged, and the names, address, and phone numbers of the witnesses, followed by, do you have documents supporting? If not, you check that box and put that response. Remember, as always, if your answer is no, just go to the next question. 72.1. Does defendant contend or base a defense or make any allegations that the notice to quit was defectively served? This means the process of getting the notice to you. Okay? This isn't about what's on the notice. It's about getting the notice to you, serving it. The main reason for a defective notice is if you didn't receive it. If it was not properly served, you never received it. The first time you saw the notice is in the complaint, meaning you didn't even have an opportunity to comply with the notice because you never received it. And this can happen for different reasons. Sometimes the landlords can be sneaky and just want to go right to the complaint and they allege that they've served it, but they don't. And other times, they tape it on the door, but it just falls off and it can just get blown away. And sometimes they have evidence that they did post it, but you never received it. You're gonna put the truthful response here. Do you believe the notice was defectively served? If yes, here. If no, here. It's a simple yes or no question. If you feel the notice was served properly, meaning it was posted in a conspicuous place on your property, if it's posted, it's supposed to also be mailed. So if it was only posted and not mailed, you could consider no. If it was properly served, if it was posted and mailed to you, you could consider yes. You're going to answer the question based on what was your experience with receiving the notice. The next question, 72.2. Does the plaintiff contend that the notice to quit referred to in the complaint was served? Obviously, this is a question for the landlord. However, sometimes it's checked. Tenants as well. If so, state the kind of notice, the date and time of service, the manner of service, the name and address of the person who served it, a description of any document or conversation between defendant and the person who served the notice. So if you don't have that information, you would check here. Otherwise, check here and write your response. Form interrogatory 72.3. Did any person receive the notice to quit referred to in the complaint? If so, for each copy of each notice, state the name of the person who received it, the kind of notice, how it was delivered, the date received, where it was delivered, and identify the identity of all documents evidencing the notice. Okay, so this question is very specific. Did any person receive the notice to quit referred to in the complaint? That means you should be looking at the notice attached to the complaint. If there is no notice attached to the complaint, then you're going to have to explain that but you'd say no because there's no notice in the complaint. It's very often exhibit number 2. If so, if it is attached, for each copy of each notice, state the name of the person who received it, the kind of notice, how it was delivered, the date received, etc. You'd check here and fill out the chart. Sometimes landlords get very notice happy, and you can put the notices they posted, the kind of notice, how they were delivered, the date you received them, and where they posted it, on the door, mailbox, wherever. You're going to indicate it here. And then check here if you have evidence of those notices, and you're going to put those in your trial binder in the exhibit category 103. And if you don't have those, if you don't have copies of the notices, you can check here and explain. $73.1. If any rent called for by the rental agreement is unpaid, state all reasons and the facts upon which the reasons are based. This falls under a section of the form interrogatories called malicious holding over. And it is rarely checked in the complaint by the landlord. Malicious holding over is when you are holding onto the property to do some form of damage to the landlord or the property, and it is rarely alleged. You should check on your complaint. I believe it's it's number 14. I'm gonna quickly pull it up for you. Hold on a second. So you know where to check. Okay, so on your complaint, on page 3 of 4, number 14 is defendant's continued possession is malicious and plaintiff is entitled to statutory damages under Code of Civil Procedure, section 1174B. State specific facts supporting a claim up to $600 in attachment 14. If that box is not checked, right, then malicious holding over is not alleged in the complaint. And for all the questions that start with 73, you can check the first box because it's not alleged. Doesn't make a difference what the question is. This is about malicious holding over. And if it wasn't checked, just check here. And otherwise, if it was, check here and write in your response. 73.2. Oh, did I read the? Oh, yes, that's about unpaid rent. Okay. 73.2. Has defendant made any attempts to secure other premises since the service of the notice or to quit, or since the service of the summons and complaint? If so, for each attempt, state the facts indicating the attempts to secure other premises, state the names, address, and telephone numbers of all persons who have knowledge of the facts, and identify all documents that support those facts. This, again, is 73, so it falls under malicious holding over. If 14 wasn't checked on page 3 of 4 of your complaint, you just put check here. Otherwise, if it was checked, you check here and you put in your response. All of these questions that start with 73 are the same in terms of if they didn't check box 14 on page 3 of 4 of your complaint, you check the first response. Otherwise, you put in your answer. 73.3 specifically asks, state the facts upon which plaintiff bases the allegation of malice. This is a question for the landlord. If it is checked for you, you can put in your response, but this is a question asking the landlord's basis. Next section is under 74. 74.1. Is there an ordinance or other local law in this jurisdiction which limits the right to evict tenants? And this is about any state or local or city or county ordinance that in some way limits the right to evict tenants. And we have legislation in the county, in the city, which does exactly that. And so most likely your answer is going to be yes. This is just a yes or no. You don't have to identify anything. It's just yes or no. Is there any ordinance or local law in this jurisdiction which limits the right to evict tenants? So it's a yes or no question. If if you live in LA County, LA City, there's legislation that does limit, it may not apply to you, but it still does limit the right to evict tenants. Next is about the specific laws of legislation in your area. Form Interrogatory 70.2. For the ordinance or local law limiting the right to evict tenants, state the title of the number of the law and the locality. Check all that apply. Okay. So the first ones are for LA City. Then you'll see there are ones that are LA County. Some of the LA County ones applied to LA City also. For example, during the pandemic, LA County extended the protections during the pandemic for 2 additional months, longer than LA City. So if you had rent that was due during the protection period of LA City, and then also once LA City's protection ended, but LA County's kicked in, you would check both. And then there's also protections for rent stabilization ordinance or tenant protection act. It's one or the other. If you have rent stabilization act, excuse me, rent stable, if your unit is protected by a rent stabilization ordinance, then the TPA doesn't apply to you, because TPA basically was a law passed in 2019 to cover people who don't have rent stabilization. It's not as strong as rent stabilization, but it gave protection to tenants who didn't have rent stabilization. And so it's one or the other. You either have rent stabilization or Tenant Protection Act protection, or neither. If neither apply, you wouldn't check either one. These down below are specific to incorporated cities in LA County. And you should add any other local ordinance that might apply to you in your specific area, if it's not listed here. If it is listed, just check it. Okay. Form Interrogatory 74.3. Do you contend that the rental unit is exempt from the eviction provisions of the ordinance or other law identified in 74.2? This is typically a question asked of the landlord. And if it's checked by the opposing counsel, they're trying to trick you. They want you to answer that, yes, it is exempt, right? Your instinct might be to answer yes. The truth of the matter is if you're protected, then no. Do you contend that the rental unit is exempt from the eviction provisions or the ordinance? Would you have some reason for your unit to be exempt from these? Most typically, your response is going to be no if checked. This is not often checked, but if it is, your response is most likely going to be no, because you don't, do you contend that your unit is exempt from those protections? If you do contend that, you can always check here and put in your response. You have to put in the information that's truthful for you, but I'm just letting you know that this is typically a question of asking the landlord if they believe you're exempt. Form Interrogatory 74.4. Is the proceeding based on allegations of a need to recover the rental unit for use of the landlord or a landlord's relative? If so, for each intended occupant, state the name, address, relationship to the landlord, reasons for occupancy, and all rental units on the property were vacated within 60 days before and after the date of the notice to quit was served. This is typically a question for the landlord to answer, but the landlord or property manager may inform you that they're wanting you to vacate the property. You would get a notice to quit, so many days to quit, because either the landlord or the landlord's relative is moving into the property. If this is checked and it doesn't apply, you just go not applicable and go on to the next question. Otherwise, you can answer here. And this information is typically in the possession of the landlord. They don't often share these details with the tenants. So if it doesn't apply here, if it does here. 74.5. Is the proceeding based on allegation that the landlord wishes to remove the rental unit from the residential use temporarily or permanently, for example, to rehabilitate, demolish, or renovate, or convert the property? If so, state each reason for removing, what physical changes will be made, date the work to begin and end, permit information, and identity of all documents. This is, again, typically a question for the landlord to answer. And if it doesn't apply to you, if the landlord hasn't given you this reason for asking you to vacate, you check here and go on to the next question. If they did give this as a reason for you to vacate, then you can check here, because very often this information is in the possession of the plaintiff, not the tenant. 74.6 is asking, is the proceeding based on any ground other than those in 74.4 and 74.5? So if it's not about the landlord or a relative moving in, and it's not about renovating the unit, what is the reason? Again, typically a question asked by the landlord, but if you know the answer, what is the proceeding based on, you would answer here. And this is where you want to put in a thorough answer of your of the facts supporting your defenses. This is the responding party opposes the facts, basically, that of what's being alleged against you, and you write out your story. Here, if this doesn't apply to you, check here. For example, if one of the reasons is that the landlord's moving a relative in, or renovation, right? If one of those is the reason, then this one wouldn't be applicable. And that's where you would check here. Otherwise, check here and put in your answer. And here you're explaining your defenses. This is why you oppose whatever is being accused against you. And any witnesses you have, name, address, and phone, and any documentation you have. And this would be your exhibits in your trial binder in your exhibit section. Check here. Otherwise, if you don't have any exhibits, you check here and explain. Form Interrogatory 75.1 is a very time-consuming one for people who have repairs that either have needed to be made or have ever if they still need to be made, or if they were a problem, but maybe they were fixed. Either way, this question is asking you to list all the conditions in need of repair in the rental unit since the beginning of your tenancy. Question specifically says, do you know of any conditions in violation of state or local business codes? Now remember, this is ors, or not and, or. So if one of these in the list doesn't apply, it doesn't mean you go on to the next question. It just make sure you read the full question. And it says, do you know of any conditions in violation of state or local business codes, housing codes, or health codes, conditions of dilapidation, or other conditions in need of repair in the rental unit or on the property that affected the rental unit at any time defendant has been in possession? So if you look at this list of possible ways of addressing the question, right, you may not know these, you may not know if they violate state or local business codes, housing codes, health codes, right? But you might know conditions of dilapidation, wear and tear, other conditions in need of repair in the rental unit or property, meaning common areas or the it could be the exterior, it could be the gate to get into the property, could be the garage, the mailbox area, the laundry room, the hallways, stairways, any part of the property or rental unit that have been in need of repair at any time while you were in possession. If so, state the type of condition, what makes it a bad condition, the kind of corrections or repairs that you believe are needed, how and when you learned of these conditions, and how these conditions were caused, and the name and address and telephone number of the person who has caused the conditions. If you live in a perfect new building that nothing has needed any repair, you check here. Otherwise, most other people would check here and list anything that has ever needed to be repaired in the unit or on the property. And if you have a pay rent or quit case, habitability is a leading defense against the amount the landlord is alleging you owe. Most people don't realize this, but if you're living in bad conditions that the landlord fails to remedy, especially if you notify the landlord of those problems, then you potentially could be granted a reduction of your rent, not just going forward until the repairs are made, but also for any months you paid full rent where you weren't getting a completely habitable unit. And it can be within your unit or on the property. The common areas, the hallways to get to your apartment, the entranceway. Sometimes buildings have bad locks, allowing strangers to enter the unit. They can do damage. They can create safety risk, health risk, security risk. There's lots of different ways that the property and the unit can have bad conditions. This you should give careful to consideration to, especially in your pay, rent, or quit cases. You want to make sure you carefully, thoroughly answer this question, putting each bad condition, the suggested repair, and when you became aware, like how long has this existed, right? And then there's a subsequent question about notifying the landlord. We'll get to that one soon. The rest of the question is about whether you know the causes of those conditions. If not, you check here. If you do, you check here and put in the response. This one's asking for the contact information for the person who caused the specific condition. If you don't know a specific person who caused the condition, you check here. If you do, you check here and put in the response. 75.2 is asking, have any corrections, repairs, or improvements been made to the rental unit since the rental unit was rented to the defendant? Typically a question asked of the landlord, but it's something that the tenant can answer to a certain degree, right? There are certain repairs that could be made to the common areas of the property that you might be unaware of and that the landlord is in possession of. But there may also be repairs to the common areas or your unit that you are very much aware of. If there were no repairs made, building is, immaculate, maybe more modern, check here, no. If there have been repairs made during the course of your tenancy, check here and indicate which repairs were made, the date, and the person who made the repairs. Some of the other information they've requested may be things that only the landlord knows, but if you do know, you can answer. This part of the question is asking about the cost of the repairs. If you don't know, you check here. If you do know, you check here and put in your response. This is about having evidence of the repairs. Usually it's the if the plaintiff is doing, if the landlord is doing the repairs, the property manager is doing the repairs, they have the evidence of those repairs. So if you don't have any evidence, you check here, but if you do, you can check here and attach the evidence to your trial binder. If there is some other response, if these responses don't adequately respond to that point, you check here and put in your answer. And then this part is about permits. If you don't know if the landlord properly got permits for any repairs, you can check here. If you know specifically one way or the other, you check here and you put in your response. 75.3 is asking, did the defendant or any other person during 36 months, that's 3 years, before the notice to quit was served, or during defendant's possession of the rental unit, notify the landlord or their agent of employee about the condition of the rental unit or property? If so, for each written or oral notice, state the substance, who made it, when and how it was made, and the name and address of each person to whom it was made, and identify each document evidencing the notice. So if you never notify your landlord about repairs that need to be made, you check here. If, however, you did notify the landlord or property manager or some other agent of the landlord about repairs that need to be made, you're going to put in the substance of the notification. What was the basis for the notification? You know, I've got problems with plumbing, electrical, rats, roaches, whatever it is, you put in here. You put the person who notified either the landlord, property manager, or the agent of the landlord, the date notification, the method, how did you communicate? Was it verbal? Was it written? Was it, you know, was it a text, an email, some other form, a letter, and the specific person that was notified for each instance of notification. And you should look towards 75.1, right? Look here, look at all the things you said needed to be repaired. And this should be the basis of your answer to this question about things that you notified. Because you look at that list of above 75.1, those are things you said needed repair. Did you notify the landlord about those things? If so, write them out here. Here, in this section, this is about evidence of notification. If you don't have, maybe you did it verbally, but you have no evidence, or you lost it, or you had evidence, but now you don't have it, you check here. If you do have evidence of notifying the landlord or the property manager or some other agent of the landlord, you check here and you include that evidence with your trial binder and the exhibit portion. Some other response that applies to you, check here and write it out. Very important that when you're trying to back up bad conditions in the unit, that you also provide evidence of notification, how you inform the landlord that the problem existed. Okay, form interrogatory 75.4. During the period beginning 36 months or 3 years before the notice to quit was served to the present, was the rental unit or property inspected for dilapidations or defective conditions by a representative of a governmental agency? If so, for each inspection, state the date, reason, name of the agency, the name and address of the inspector, identify any document evidencing each inspection. Now, sometimes where we might be aware that an inspection is happening, but we don't know a lot of information about why or the details of it. If that is true, you can check here that responding party is unable to respond, but believes that the information may be in the possession of the plaintiff. If, however, you do know of specific instances of a governmental agency like LAHD coming out to inspect the property or your unit, you check here, you put in the inspection date, the reason for the inspection, the agency, and if you have it, the inspector's contact information. You're going to answer this question like all questions to the best of your ability. You're going to put in whatever information you know. Sometimes we don't have all the information, but you're going to put in what information you do know. And then this is about documentation of any evidence of governmental agency inspection. If you have evidence, you're going to put that in your trial binder and check here. Otherwise, you can check here and explain. Form Interrogatory 75.5. During the period beginning 36 months or 3 years before the notice to quit was served to the present, did the plaintiff or landlord receive a notice or other communication regarding the condition of the rental unit or property, including other rental units, from a governmental agency? If so, for each notice of communication, state the date received, the identity of all parties, the substance of the notice or communication, the identity of each document evidencing the notice or communication, and the name, address, and telephone number of each person who has it. Typically, this is a question for the landlord or property manager to answer. However, sometimes the governmental agency will give the tenant a notice letting them know exactly what violations were found on the property that the landlord must remedy, usually giving the landlord a certain amount of time and perhaps a follow-up inspection. If you have that evidence, you would write out that here in the chart. You check yes and answer these questions, these points: the date the notice received, the parties involved, substance of the notice, what was the violation, the documents, and phone numbers of witnesses. If you don't have any information, you just check here. Doesn't mean it didn't happen. It just means that you aren't able to respond because this information may not be in your knowledge, but you believe if it does exist, it's in the possession of the plaintiff. Down below here is about having evidence from the government agency. If you do have evidence, you would check here and put that evidence in your binder. Otherwise, check here and explain. Form Interrogatory 75.6. Was there any corrective action taken in response to an inspection or notice or communication identified in sections 75.4 and 75.5? If so, for each, identify the notice or communication, identify the condition, describe the corrective action, identify each document evidencing the corrective action. Again, a question for the plaintiff to answer, but the tenant may also have information that you could put in here. If you don't know, you can put in here. It's not saying that it didn't happen. It's just saying that the information may be in the possession of the plaintiff instead, the landlord or the property manager. If you do have specific information, meaning you know the landlord responded to a notice of violation from a governmental agency, actually made some repairs, and you're also going to want to make sure you're clear about how well they did those repairs. Did they do them completely, or maybe it wasn't fully repaired? You're going to explain that all in here. The type of notice that the landlord had received to remedy some problem on the unit, the specific problem in the unit or the property, and what corrective action was taken. And here, this is about any documents you have evidencing whatever you put in here. Remember, if you answer here, if you check this box, just go to the next question. If you check here, fill out the chart, and then answer this question about whether you have anything tangible, any tangible evidence, emails, notices, text messages, to back up whatever you put in for response up here. If you don't have evidence, if you do have evidence, put it in your trial binder in the exhibit section. Otherwise, check here and write out your response. 75.7. Come on. $75.7 is asking, has the property been appraised for sale or loan from the period 36 months or 3 years before the notice to quit was served to the present? If so, for each appraisal, state the date, the appraiser, the purpose, and any documents evidencing. If you aren't sure, you check here. And this isn't saying that it didn't happen, it's just saying you don't know, but the landlord, if it did happen, the landlord knows. If you do know specific information about any appraisal for sale or loan, you're going to put in the information you have here. And then any evidence you have of that here. If you have evidence of it, you include it in your trial binder in the exhibit section, check here. Otherwise, check here and put in your response. 75.8 is asking, was any condition requiring repair or correction at the property or rental unit caused by the defendant or any occupant of the rental unit or their guests? If so, state the type and location of condition, the kind of correction or repairs needed, how and when you learned of these conditions, how and when these conditions were caused, the name and address and telephone number of each person who caused these conditions, the identity of each document evidencing the repair or correction, and the name, address, and telephone number of each person who has any document. If this doesn't apply to you, if you, anyone else living in the unit, or any of your guests never caused any damage to the property that needed repair or correction, you check no and go on to the next question. Otherwise, you're going to put your answers to these here. Check here and answer. And then this is about, F is about having evidence, tangible evidence. If you have evidence, check here, put it in your trial binder in the exhibit section. Otherwise, check here and explain. 76.1 is asking, did the plaintiff or landlord or anyone acting on their behalf do anything which is alleged to be a waiver, a change or withdrawal or cancellation of the notice to quit? If so, state the facts supporting the allegation, the names, addresses of all persons who have knowledge of these facts, and identify each document that supports the facts. A waiver is a change to an agreement, and it can often have legal ramifications. So, for example, the question is specifically asking about whether the notice to quit, right? Often the landlords, they issue a notice and they don't act on it for one reason or another, and they issue a new notice. And that new notice is meant often to supersede the previous one, meaning the previous one has been changed, withdrawn, or canceled. And that can have a legal ramification for the notice, because the court recognizes that if there's a change to an understanding or agreement, the person on the other side of that may read into that the change applies instead of the previous rule that was in place. The most basic way of explaining a waiver in terms of tenancy is, hypothetically, if the landlord in your rental agreement says your rent is due on the 1st of the month, and maybe they put in a grace period of 5 days, so that if the long as your rent is paid by the 5th, it's paid on time, no consequence. But if it's paid late, it may state in your lease or rental agreement that after the 5th or after the 1st, you must pay a late charge, a late fee. But say hypothetically, you pay, it's due on the, by the 5th, you pay on the 7th, and the landlord says to you, don't worry about it, I'm not going to charge you a late fee. You got me the rent, it's all good. That changes the agreement going forward. Not just for that instance, but now you have a new understanding with your landlord. that the landlord has changed what it said in the lease or rental agreement, and that creates a waiver, a new understanding of the agreement when it comes to late payments, that you can pay late without consequence. And this can also be applied when it comes to the notice. If you receive a notice from the landlord that says you must do this or move, that notice expires, the landlord doesn't act on that notice, then that can change what you believe is the consequence of that notice. If the notice expires, the landlord doesn't follow through with an eviction based on that notice, it can be a logical expectation from the tenant that the landlord is not going to act on, or there's not going to be a consequence to the notice. And so here specifically, the question is asking, did the plaintiff or landlord or anyone acting on their behalf do anything which is alleged to be a waiver, change, withdrawal, or cancellation of the notice to quit? If you received multiple notices, then you should put this response and put in an explanation here. If you only received one notice, that notice expired and the landlord filed an eviction, you can check here. But remember that waiver, change, withdrawal, or cancellation of an agreement applies to potentially lots of different things. And so you should consider if the landlord changed in any way your understanding of consequences to paying late. If they changed the agreement that was in the lease to something new that led to you not paying the rent on time, thinking there were no consequences, you can check here and explain that. If it doesn't apply to you in any way, shape, or form, you only received one notice, check here. If otherwise, you're going to explain here. Here is any evidence you might have, including multiple notices, or evidence you might have of paying your rent late with no consequence. You want to put that evidence in your exhibit binder, your exhibit portion of your trial binder. If you don't have the evidence, check here and explain here. 76.2. Did the plaintiff or landlord accept rent which covered a period after the date for vacating the rental unit as specified in the notice to quit? If so, state the facts, the names and address of all persons who have knowledge of these facts, and identify each document that supports the facts. This is about when you're given a notice, especially when it comes to a notice to pay rent or quit. Say the notice gives you 3 business days to comply, and then the notice expires, and you find yourself able to pay the rent. The notice has expired, and you go to the landlord and say, I have the money, or maybe it's a portion of the money that was demanded in the notice, and the landlord accepts that payment after the notice expired. If the landlord accepted any money after the notice expired, you want to detail that information here, because technically, after the notice expires, the court has jurisdiction over the case. The landlord's not allowed to legally accept rent, and it could reinstate your tenancy. The landlord might still follow through with an eviction lawsuit based on the portion of rent you didn't give them. Maybe they demanded a certain amount and you paid a portion of it, they accepted it, but they now move forward with the eviction lawsuit based on the balance. That can be a problem for the landlord because the notice stated a larger amount. They accepted rent that they weren't supposed to accept because the notice has expired and the court has jurisdiction now over the case. They accepted that rent. It doesn't, not necessarily 100%, but it can be a reason for the case to be dismissed. And so you want to make sure you have evidence of any payment that the landlord accepted. And accepted means they deposit it in their account. If you mail a personal check or even give them a personal check that they don't deposit, that's not accepting. A personal check, just so everyone understands, is the promise of payment. It doesn't mean payment because there's no guarantee that there's money in the account to bank to cover the check. A cashier's check or a money order, if accepted by the landlord, is greater evidence of acceptance, but they must deposit it. They have the landlord, if you make a payment after the notice to quit expires, the landlord has an opportunity to, they receive it, maybe you send it to them in the mail or some other way, they can send it back to you. If they hold on to it for a long period of time, for some reason, you might have a case for landlord accepting the rent. And you should talk about that with your attorney law clerk team. But if whatever your circumstances are, you're going to put here. If the landlord never accepted rent after the notice to quit expired, check no, go to the next question. If they did, you're going to put in the date, who paid, who received, the amount, and any person who has knowledge of that payment. This is that if you don't have any evidence of making that payment, check here. If you do, put it in your trial binder in the exhibit section here. Otherwise, check here and write out your response. Okay, 77.1. State all reasons that the notice to quit was served or that the the responding party's tenancy was not renewed. And for each reason, state all facts supporting plaintiff's decision to terminate or not renew responding party's tenancy. State the names, addresses, and telephone numbers of all persons who have knowledge of the facts and identify all documents supporting the facts. This is typically a question that's asked of the landlord. It's asking for plaintiff's decision, right? So consider that when you're answering the question. If you don't know, you check here. It means you don't have information, but you suspect the landlord does. If you are able to answer this question, check here and put your answers here. And then this part is about whether you have documents. If you do have documents, check here. Otherwise, check here and put in your explanation. 78.1. Did the landlord or anyone acting on the landlord's behalf agree to make repairs, alterations, or improvements at any time or provide services to the property or rental unit? If so, for each agreement, state the substance of the agreement, when it was made, whether it was written or oral, by whom and to whom, the name and address of each person who knows about it, whether all promised repairs, alterations, or improvements were completed or services provided, the reasons for any failure to perform, the identity of each document evidencing the agreement. And this can be for either party to answer. If it doesn't apply to you, check no and go on to the next question. If it does apply to you, check yes, and then put in your response here. This is about the landlord agreeing to make repairs. Doesn't mean they did make the repairs. It's just establishing an agreement. It's when you contact the landlord and say, there's this problem, and the landlord says, okay, I'm going to fix it. That's an agreement to fix. And you're going to put in the substance of the agreement, the date the agreement was made, how it was made. Was it a conversation over the phone or in person or written in some way? The parties involved, any witnesses, and were the repairs actually completed? This is just the landlord agreeing to make the repairs. If they didn't follow through, you would explain that here. Down here, the question is about whether the landlord's reason for failing to perform if they failed to perform. If you don't know their reason, you check it here. If you do have an understanding, and you can check here and put your answer here. And the next section below is about having documents. If you have no evidence, no tangible evidence, you check here. Otherwise, you check here and put that evidence in your trial binder in the exhibit section. Any other response, check here and answer. 78.2. Has the plaintiff or landlord or any resident of the property ever committed disturbances or interfered with the quiet enjoyment of the rental unit? This is about landlord harassment or resident of the property harassment or any other type of disturbance or interference with your quiet enjoyment of the rental unit. Now, for example, harassment can be that you have a reasonable explanation for not being able to pay your rent, and your landlord is banging on your door, screaming at you through the door. All your neighbors are aware because the landlord is screaming and harassing you. You're not able to enjoy the unit. And the landlord is expecting to get money either now or later for that month. And so they have to keep their end of the bargain, which is to give you quiet enjoyment of the rental unit. If at some point the landlord is going to collect for that month, they had to have given you a habitable unit that you can enjoy. And so if they do something to disrupt that enjoyment, you're going to explain that here. If there is no evidence of any type of disturbance from the landlord, the property manager, any other agent of the landlord, or from anyone else that lives at the property, you check no and go on to the next question. Otherwise, you check yes and you explain. What was the disturbance or harassment here, the date that it happened, and any information about witnesses here. And then down below, it's asking, if you don't have any evidence, you check here. If you do, you check here. You put it in your exhibit section of your binder. If neither of those apply and there's a different answer, right, check here and write it out. And then this part of the question is about whether the plaintiff or landlord took action to end or lessen the disturbance. And so if yes, you can explain how the landlord or plaintiff did that. If no, you can say the plaintiff, the landlord, potentially is the person causing the disturbance and did nothing. Or they did nothing to disturb, to lessen the disturbance by some other tenants of the property. So if they did, if the landlord or property manager did something to reduce the harassment, you put it here. If they didn't, you check here. For interrogatory 79.1, has defendant or anyone acting on the defendant's behalf offered any payment to plaintiff which plaintiff refused to accept? If so, for each offer, state the amount, the date, the purpose of offer, the manner of the offer, the identity of the person making the offer, the identity of the person refusing the offer, the date of the refusal, and reasons for the refusal. If this doesn't apply to you, check no and go on to the next question. If it does, then you're going to answer and put your information, answer to these questions in here. And this is about trying to make a payment that the landlord or property manager is refusing to accept. And sometimes landlords and property managers will try to refuse to accept a partial payment. And you're going to want to document that because they're going to allege potentially you owe all this money, and you can say, well, not so fast. I tried to pay a portion of that. The landlord refused to accept it. And sometimes the reason for refusal is the landlord or property manager will say, it's all or nothing. You got to pay all the money you owe, or we're not accepting any portion. And you're going to explain that here. You're going to put the amount, the date, the offer, the purpose, to pay rent, the manner, how are you paying the money? How are you proposing, check, cash, whatever, hopefully cashier's check or money order, the person who's making the offer, the person who you are making the offer to, and the date of refusal. And you can explain up here information about what actually happened. And if the plaintiff's reason for refusing the payment is not within your knowledge, you check here. However, if they made it known to you, for example, we're not going to accept it because you're not paying the entire amount owed, you can check here and write out that explanation. Whatever the honest, accurate information answer is, that's what you put. Remember, if you checked here, just go on to the next checked question. You only have to answer the questions that were checked by the opposing counsel you don't answer the other questions. If it's not checked, you don't answer it. If it's checked, you answer to the best of your ability. Form interrogatory 80.1. Does defendant claim to have deducted from rent any amount which was withheld to make repairs after communication to the landlord of the need of the repairs? All the questions that start with 80, 80.1, 80.2, etc., are about the remedy, the repair and deduct remedy. And this means you had an agreement with the landlord to fix something yourself and then deduct it from the rent. If that doesn't apply to you, right, then, you know, you're going to check no here. And then for each of the following questions that start with 80, you just have to check here for this interrogatory doesn't need to be responded to because repair and deduct remedy was not raised as a defense. If it didn't apply to you, these questions don't apply to you. This applies to all questions that start with 80. They are all about repair and deduct remedy. And you can look to your answer for repair and deduct remedy. Did you check that as a defense? If you checked it as a defense, then you should have some example of something that needed repair. You contacted the landlord. The landlord said, I don't have anyone or any ability to take care of that now, but I understand that it's urgent for you. Can you fix it yourself? You come to an agreement with the landlord about taking on that repair yourself. This can mean either you doing the fix, you hiring someone to do the fix. Often it requires getting bids so that the landlord can agree on the bid to do the repair. And if this doesn't apply to you at all, just check no. And then for each of these questions, if they're checked, check the first response, which is the interrogatory does not need to be responded to because the repair or deduct remedy was not raised as a defense. If this question is yes, if your answer to this question is yes, if you did have an instance where you deducted from the rent an amount because you communicated to the landlord about repairs that needed to be made, and you came to an agreement with the landlord about deducting that amount from your rent, check here. And then for each of the questions that begin with 80, you're going to put in information answering those interrogatories. The first question is yes or no. Either it applies or it doesn't. Next question, 80.2. For each condition in need of repair for which a deduction was made, state the nature of the condition, the location, the date the condition was discovered, the date the condition was first known by the landlord, the dates, methods of each notice to the landlord of the condition, the response or action taken by the landlord, the cost to remedy the condition, and the cost determined, and the identity of any bids obtained for any repairs, any document evidencing the bids. So again, if it doesn't apply, check here. If you didn't raise this as a defense because it didn't happen, check here. Otherwise, check here and fill out the table based on these questions. The nature of the repair, the location, the date you discover the problem, the date you first notified the landlord or property manager, the date and method of notice to the landlord, property manager, and the response from the plaintiff or the property manager, meaning the landlord or property manager saying, yes, you can take on this repair and, you know, get us bids or whatever the situation is, and yes, you can deduct the amount. That's the response that they're looking for. Only if this applies to you. If it doesn't apply, check here and go on to the next question. This is about whether you have knowledge to the cost to remedy or not. This is about knowledge of any bids obtained. Sometimes the landlord will be involved in the bidding part and allow you to take it from there. So answer these questions if they apply to you as accurately as you can. 80.3, again, these next two questions fall under 80, under remedy, under repair and deduct remedy. So in both of these next questions, if your answer was no above to the first one, then the answer is going to be the first response here. First response here. The interrogatory doesn't need to be responded to because repair and deduct remedy was not raised as a defense. Otherwise, answer the question. And the question is, did the landlord or plaintiff fail to respond within a reasonable amount of time after receiving a communication of a need to repair? Meaning, you've notified the landlord about a repair that's urgent, and you're willing to take on the repair yourself, but the landlord isn't responding, isn't giving you, yes, you can do it. Yes, I'll allow you to deduct it from your rent. Yes, I agree to the amount. If the landlord isn't responding in a reasonable amount of time, you're going to fill out this chart. Doesn't apply to you, check here and go on to the next question. 80.4 again, and 80.5 again. If repair and deduct remedy was not raised as a defense, check here, check here. If it was raised, the question is, was there an insufficient period specified or actually allowed between the time of notification and the time repairs were begun by defendant to allow landlord or plaintiff to make repairs? This is a question typically for the landlord or the property manager to answer, and that's why the second response is that you're unable to respond, but the information requested may be in the possession of the plaintiff or the property manager. Any other response, check here and put in your answer. 80.5. Does plaintiff contend that any of the items for which rent deductions were taken were not allowable under law? If so, for each item, state all reasons and facts on which you base your contention. This is a question for the landlord to answer. But if this was checked for you to answer and repair and deduct remedy was not raised as a defense because it doesn't apply to you, check here and go on to the next question. If you did include repair and deduct remedy as a defense in your answer, then you should answer this question. But this is a question for the plaintiff, so you would most likely check here. Otherwise, you check here and write out your response. 80.6, still a repair and deduct remedy question, but it doesn't apply to you. Check here. The question is asking, has defendant vacated or does defendant anticipate vacating the unit because repairs were requested and not made within a reasonable amount of time? This question is specific to a situation in which the repairs are so egregious you would need to vacate the unit, meaning the unit isn't habitable. You've got to vacate the unit while the repairs are being made. If that was the case, and you had a discussion about repair and deduct with your landlord, if you did, have you vacated or do you anticipate vacating? If that doesn't apply to you, no. If yes, then state all facts, meaning I had to vacate because there was so much mold I would have gotten sick. Whatever the reason is that you needed to have this repair made that was so bad you could not live in the unit while either waiting for the repair or while the repair was being made. Sometimes the repair itself, the work that's involved, can be so disruptive that you can't live in the unit while it's happening. And so sometimes you'll have reasons to vacate. And oftentimes you come to an agreement with the landlord about needing to stay in a hotel or some other place where they agree to cover the costs. If that's the case, you're going to explain, check here, and write out the answer. Form interrogatory 81.1. Do you have an opinion on the fair market value of the rental unit? If so, state the substance of your opinion, the factors upon which fair market rental unit is based, the method used to calculate the fair market value. And, you know, the way that the EDN attorneys have put in their responses here is, you know, if you're not an expert and you don't have an opinion on the fair market value, check here. This may not be your area of expertise to calculate all the different possible reasons that the value of your unit might be this or that. You don't know, check here. If you are an expert in this area, you can check here and explain why you have an opinion about the fair market value of your unit. Same thing with this question. Has any other person ever expressed you an opinion? on the fair market value of the unit. If you don't, if this doesn't apply to you, check here. If there's not been a person that you brought in that's an expert, check here. Otherwise, check here and put in your explanation. And the last question in the form interrogatories unlawful detainer is question 81.3. And 81.3 is very similar to question 75.1. And so you can actually put your answer to 75.1 in this response. 81.3 asks, do you know of any current violations of state or local building codes, housing codes, or health codes, conditions of dilapidation, or other conditions in need of repair in the rental unit or common area that have affected the rental unit at any time defendant has been in possession? Very similar to question 75.1, and therefore you can put in the response to 75.1. You can check here. If 75.1 was checked, you can check, and you responded to it, you can check here and say refer to response to 70.1, noting also that there could be things, right? There could be repairs that you don't know about that still, or conditions of, repair that are needed that you might not be aware of that are in the property or rental unit, common areas, etc., that you don't know of, but the landlord does know. So this is basically saying I've answered in 75.1 what I know about. There may be things the landlord knows about that I don't know. That would be checking this answer. You check this answer if you are not able to respond because you believe the answer is solely with the plaintiff, meaning you didn't have any repairs that you were aware of, but it doesn't mean that there weren't any. It just means that they would be in possession of the plaintiff. Or you can put answer no, if that is the answer you think is truthful. If 75.1 wasn't checked for you to answer, you didn't respond to 75.1, then you should respond here to that question, and you would answer it very similar to the way you answered 75.1, or would have answered 75.1, which is what is the bad condition, the repair needed, and how did you learn of that condition? How and when did you learn of that condition? And then at the bottom, were any of these the causes of these conditions? Are they the causes in your knowledge? If no, you check here. Otherwise, you check here and put in your explanation. Do you have the contact information for the person who caused the conditions? If no, you check here. Otherwise, you check here and put in your answer. And that is the end of the form interrogatories unlawful detainer. As a reminder, you only have to answer the questions that are checked by the opposing counsel for you to answer. And remember, as we went through, if the question doesn't apply to you, make sure you check the appropriate box and put in the correct response that applies to you. If it's not within your knowledge, if you're guessing, use the response that applies to you. Very often there's responses that allow you to put in that it's not within your knowledge, because very commonly these are questions asked of the plaintiff, not the tenant, and therefore the plaintiff would be the one most appropriate to have the answer. At the end of doing your discovery, that when you're done, not when you started and haven't finished, when it's all done, and when it's been, if you got assistance from EDN or someone else, you should wait until it's been reviewed. If no one is available to review it and you finished it and you're going to send it, the date that you're sending it to the plaintiff's attorney is the date you're going to put here. You sign it here. You then have to also put in this information and sign the verification page. You put your name here, you put the date and the location here, and sign here. If you don't fill out and sign the verification page, it's as if you didn't answer the questions, because this is declaring under penalty of perjury that the foregoing is true and correct. again, you're going to date it based on the date you're sending the responses. So don't, when you first start this, don't say, well, I'm just going to put in today's date, and then a week later you finish. No, you're going to wait until you're completely done, because this is saying I verify all the responses at the end, when I'm done, that this is true and correct. Date, location, wherever you are, Los Angeles, and your signature. If the person who's responding does not speak English and needs to have the responses translated to them, this is the verification page for someone who does not speak English. If you speak English, use this response and delete. You can delete this one or just leave it blank. You must sign and date one of the verifications. The proof of service is how the responses are going to get to the plaintiff, okay? The law requires that the person who does the proof of service, who sends these to the plaintiff on your behalf, be someone who's an adult, 18 or over, who's not party to the action, meaning they're not named in the complaint. And that person should put their address and the date, and the dates of proof of service should be the same dates as the verification and the dates you sign here. All of this should happen on the same day. Make sure before you put in those dates that it's the date you're going to actually serve it to the plaintiff. And typically we send the responses digitally, scan them, and send them via email. You have to check the way you're serving. If you're mailing them, you're going to put in the address of the law firm here and check here. If you're mailing them and sending them another way, right, whether it be first class or overnight, whatever it is, you're going to check the appropriate boxes of service. In my case, when I had my case, I both emailed them, and because the law firm was right down the street from me, I checked here and I checked here and I dated and I emailed it, and I also brought it to them in person. I wanted to make sure that they couldn't say they didn't receive it. And so I did both. But you only have to do one. Email is usually sufficient. Sometimes, I would even say rarely, the law firm will acknowledge receiving them. Every once in a while, rarely, they'll say received. Most often you won't get that response, but don't think that it didn't get received. Try to get, if you're using email, try to get multiple emails. Like, who are the attorneys involved? Get their individual emails. What do they have? A general email for the law firm? Get that email. Put all the email addresses here and send them. When you send the responses, you're going to send it to all those emails. It's less likely they're going to be able to say they didn't receive it for whatever reason if you send it to multiple people. So remember, person not involved in the case, adults over 18 years of age, the date here should be the date you actually send it. If you're sending it by mail or email, whatever the way of service, you're going to check X, put an X or check in the box here under the service, and then the date it's actually served and the signature of that person who's doing the proof of service. This is the person who's sending it on your behalf. And then this would go on to the next section of the discovery. And that concludes this portion of the video, which I'm now going to end, and then we'll take questions. Give me 1 second.